Okay, I'll go ahead and hit the go live button. So everything after this should be live.
Okay. Good morning. I'm Cynthia Schendel, and I serve as co-chair of the Social Work Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. Andrea Perdomo Morales, Donna Honer-Queel, Sarah Behrens,
Present.
Mary Gill,
Present.
Mike Gillette, Leanne Gingery, Angie Heiler-Workman,
Angie Heller-Workman, present.
thank you. Jane Holstrichter.
Present.
Good morning. Catherine
morning.
Reck. Eric Schonecker.
Present.
Kristen Stice.
Present.
And Robin Unruh.
Present.
I note that the following BSRB staff members are also present: David Fye and Leslie Allen. Next, David Fye will read a message concerning this meeting being held remotely.
Thank you, Cynthia. And Leanne Gingery has also entered the meeting as well, so she is present.
Great.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the Executive Director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting as no individuals requested to provide public comment. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by a medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the KOMA are not suspended, so we will be conducting this meeting pursuant to the KOMA. On May 22nd, 2023, we sent notice of the advisory committee meeting to all individuals who requested notice of advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov, and you may obtain a copy of the notice at that website. An agenda and other media material have been posted on the board's website and are available for review. Members of the public may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line "request for the agenda," and it will be sent to them. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, they may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And the conference call line is active. I did check that before we started the meeting, and there's no one currently on the conference call line.
Okay, thank you, David. We'll go ahead and get started and ask for approval of the agenda. Did everyone receive it?
Yes, I got one.
Great. It was attached to the email that had this link in it. So do I have a motion to approve the minutes from our April 24th meeting?
This is Lee. I motion to approve our minutes.
Thank you, Leanne. Any second?
This is Jane. I'll second.
Thanks, Jane. All in favor, say aye.
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 Any opposed? Okay, motion passes. The agenda is approved. And now we need to approve that. I'm sorry, my motion was about the minutes and it should have been about the agenda. So we're doing it backwards. We just approved the minutes from our last meeting and now we need to approve the agenda for this meeting. So I need a motion for that as well.
This is Lee, and I motion to approve the agenda.
Thank you. And the second?
I second.
Thank you very much. Thank you, Angie. All in favor? Aye.
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 Any opposed? Okay, the agenda passes. So now we'll move on to the executive director's report. David?
All right, thank you, Cynthia.
Mhm.
I'll start with some operations updates and then talk about some legislative updates, and then we'll cover a couple other items from a recent board meeting. So in terms of operations updates, specifically on IT, we are working on implementing many of the provisions from a recently passed bill that was sub for Senate Bill 131. And I'll talk about that bill in a little bit more detail a little later. But as part of that bill, we received authority to hire 2 new licensing specialists to assist us with some of our responsibilities and some of the new responsibilities from that bill. And so we are working through those logistics. I've drafted position descriptions, submitted those for us to receive authority to hire. We wouldn't be able to bring those individuals on board until the start of the next fiscal year, which starts on July 1st, 2023. But we're trying to lay the groundwork so we can bring those individuals in, hopefully shortly after the fiscal year begins. We'll still need to put out the advertisement and interview candidates, but I'm hopeful we can find individuals quickly after the start of the fiscal year. Additionally, under the umbrella of IT, we began a process 2 years ago when I came on board of moving staff members from their existing desktop computers to new laptops under desktop as a service through the state's leasing program for technology. We started a phase-in approach 2 years ago, and we moved some of the staff members. And then last year we moved some additional members, and this year we're transitioning the last 5 members onto those new computers. So we'll have a staggered approach and not everyone will come up at the same time. Additionally, we did receive funding through a federal grant, essentially, that we had applied for to receive some money from the federal government. It was Spark funding that was made available to state agencies and other entities to apply for funding under the umbrella of modernization of equipment. So we received some funding for a new OWL camera for the boardroom to allow us to do hybrid meetings as we move forward after the pandemic has resolved. And then we also purchased a new projector for the board meeting, which allows us also to use that in combination with the OWL camera for the hybrid meetings. Overall, we saved the agency about $2,100 with that funding. And so we're passing along that savings in terms of not needing to look at raising fees or other cost efficiencies if we can find them. In terms of some legislative updates, there was a discussion on a budget proviso for the agency's budget this year, and I just kind of wanted to complete that discussion on the proviso. So essentially, just as a reminder, the BSRB is a fee-funded agency. We don't receive any money from the state for operations, but we operate based on the licensing revenue that we receive primarily. And essentially, by statute, we contribute 10% of all revenue up to a yearly cap to the state general fund to help fund the state's operations. But the legislature each year passes a budget bill, and for agencies like the BSRB, they establish a limit. And that limit says that even if we had additional funding in our fee fund account, we could only spend up to a certain dollar amount each year. And so as part of this process, we put together a budget of expected costs and expenditures, and we submit that for approval from the governor's office, and then ultimately the legislature reviews that too. And so we submitted that, and both the House and the Senate review the agency's budget separately and then come together on a joint budget bill. On the Senate side, the Senate committee concurred with the same totals that the governor had recommended for the agency for fiscal year 2023, which is what we're currently in, as well as new budget requests for fiscal year 2024 and 2025 with no changes. On the House side, they recommended the same amounts that the governor had recommended. However, they added language. And when I said proviso, that's essentially what the language is. A proviso on an agency's budget would mean that the agency either can't spend money specifically for something or would need to spend money on something. So it either requires you to do something or prohibits you from doing something. In this case, during the budget hearing, they had asked questions about an item that was in a separate bill that had been requested on behalf of the BSRB. And in that separate bill, one of the items the board was supportive of and had requested in a bill would be a new requirement of continuing education in the area of cultural diversity. And so they asked questions about that policy bill during the budget hearing. And ultimately, when they passed out the agency's budget from that budget committee, they went ahead and added language that would prohibit the agency from requiring as a condition of licensure or renewal education or training in the areas of diversity, equity, and inclusion, critical race theory, and some other related topics. That went to the the budget committee in the House Appropriations Committee, and stayed on the agency's budget that ultimately was in the House version of the budget bill they passed. And then when the House passed its budget bill, the Senate passed their budget bill. They met together to resolve items of difference. They decided to keep that proviso on the agency's budget in the final appropriations bill. And then that bill was passed and sent to the governor for review. And then the governor has the authority to do vetoes on bills. And specifically for appropriations bills, the governor has authority to do what is called line item vetoes, where the governor can veto only portions of a bill instead of the whole bill. And so for appropriations bills, the proviso that was on the BSRB's budget was an item that she was able to line item veto. So she did line item veto that additional language. When the legislature came back for the very end of session, it's called omnibus usually, they were able to consider potentially overriding vetoes. And they made a list of veto override attempts, and the House considered those first. And on the item that involved the language for the BSRB, by one vote, that veto override attempt failed, which means that the governor's veto of the language stays, which means that the language essentially goes away. So I realize it's a little complicated, but I wanted you to kind of walk through those steps as we've been tracking that. Ultimately, that language that was considered and was on for most of the legislative session has gone away. And so it's not something that we need to focus on going forward. However, it did receive a lot of attention, so I wanted to bring that to your attention as well. And I'll go ahead and pause here to see if you have any questions specifically on that proviso or on the agency's budget.
I have a question. The equipment that was purchased, is that the type of camera that turns towards whoever's speaking? So
Yeah.
that, okay, awesome. And then on this bill, are they likely is that likely to come back up in a separate bill next session, do you think?
The proviso language on the DE.
Their attempt to exclude that provision, yeah.
Yeah, it's hard to predict. I know that there was some similar movement on an item involving the universities that had to do. I didn't follow that as closely, but this is definitely a hot topic in terms of politics, and so it wouldn't surprise me. Now, to my knowledge, I don't believe that there were other similar boards to us that received that kind of proviso language. So I think it's likely if it comes up again, they might take more of an across the board approach to it. But we'll just kind of have to take a wait and see approach, I think.
But the bill included a provision, our bill, BSRB bill, that would replace 3 of the 6 hours that were diagnosis and treatment with diversity and equity training, and that now stands.
No, so I'll go into kind of a big update on the bill itself.
Okay.
But you are correct. The original bill that was requested by the legislature would have introduced a new requirement of continuing education and cultural diversity. It would be a 3-hour requirement for all licensees, but that was removed from the bill. So that didn't pass. As part of that, the board had looked at what they currently require for continuing education, and for the levels of licensure that we're able to diagnose and treat. There's currently a requirement of 6 hours in diagnosis and treatment every 2-year license cycle. Now, in looking at what other states require, that 6 hours in diagnosis and treatment was a bit unusual. And so not wanting to limit the total number of hours and what individuals could choose to take, but also wanting to prioritize both topics, the board had made a recommendation to lower from 6 to 3 the hours in diagnosis and treatment, while introducing that new 3-hour requirement in cultural diversity. But as we talked about, that item got removed from the bill. So the new 3-hour requirement in cultural diversity is not in the bill. Now, I'll talk about this here in a second, but the legislature did choose to go ahead and lower the hours in diagnosis and treatment from 6 to 3, and that will begin as of July 1st, 2025. So that won't affect the individuals who are currently in their licensure cycle, but for the individuals who will be starting the new cycle here after June, or at least starting July 1st, 2025, that's when that will become a new standard. It will reduce from 6 to 3 that hours in diagnosis and treatment. So,
okay, thanks.
But I'll go ahead and provide a general update on that bill. So the BSRB The board and you as advisory committee members to assist the board, you all worked very hard last year considering a number of possible recommendations. We were focusing on trying to look at items such as workforce, also looking to see, how can we add in items to better protect the public and address a number of different issues and topics. And so the ultimate bill the board recommended was a very lengthy bill. And it was a very, very important bill. It included some statutory cleanup of items that were definitely needing to be cleaned up, and it introduced a lot of new license types. And ultimately, that bill was introduced in front of the legislature originally as House Bill 2340. We talked at the last meeting about that bill had gone to the House Health and Human Services Committee, that they had removed 3 items from the bill and had added 3 new items to the bill. And then the bill did pass the House, and then it went to the Senate, and the Senate Public Health and Welfare Committee considered that bill. And I did meet with each of the members of that committee and request changes and talk to each one of those members and presented testimony, attempting to resolve some issues that were caused due to the legislative activity when the House was considering the bill. And unfortunately, we were not able to have those amendments brought forward and passed to resolve those issues. And the last time I talked to you, the legislature was at a break, but essentially before they had left, they had combined the BSRB bill with 2 other bills that related to health in Senate Bill 131. That was part of the conference committee process where you can combine multiple bills into one bill, but the bill had not passed at that time. Since that time, the legislature did come back and passed Senate Bill 131, and then the governor did sign that bill into law. So that bill will become effective as of July 1st, 2023. There are many different items in the final version of the bill. So I think I'll take a moment now and just kind of walk through the different items that are part of the bill, just to kind of clarify what's in the final version of the bill. So one of the items deals with reciprocity. This is one of the big items the board had talked about. For most of the professions under the board, there is a statute that guides the reciprocity process to become licensed. And what it states is that to become licensed by reciprocity, you would need to have become licensed in a jurisdiction with substantially equivalent license requirements or have met other requirements. And one of those other requirements was to have practiced in the other jurisdiction for 48 of the last 54 months. But a couple of years ago, there was a bill dealing with reciprocity for certain military members, military spouses, that also dealt with individuals who reside in Kansas and some that intend to reside in Kansas. And so what the board looked at in terms of the statute was wanting to make the standard more suitable, and it also would sync it up with that military bill. So the board recommended reducing the number of years of practice down from those 48 of 54 months down to 12 months in another jurisdiction with a similar scope of practice. And so that was in the final version of the bill for most of the individuals applying for reciprocity. And so now the standard in that statute is for them to have a license in another jurisdiction with a similar scope of practice for 12 months. And then they would have to meet a few other requirements in that statute. Additionally, there was language that dealt with an issue we've talked a little bit about, and that is that for schools that are starting, that are trying to become accredited by CSWE, that accreditation process can take 3 to 3.5 years. And we have seen new programs start, and those programs are seeking to become accredited, but they're in something called candidacy for accreditation, where they're meeting certain benchmarks along the way. And students will go through the program. And the question is, well, how should the BSRB handle these applicants while their program is in candidacy for accreditation? And the board did research on this topic and looked at a model that's being used in Minnesota that allows the board to issue a temporary license for those individuals who graduate from programs that are in candidacy that have been able to pass the licensing examination. So essentially what would happen is these applicants would apply like just normal applicant. And then if they are attending a school that's in candidacy for accreditation, then they would be able to meet the standard to be able to take the licensing examination. And if they pass the licensing examination, then they would be able to receive this new candidacy temporary license as long as their school remains in candidacy for accreditation. And if their school becomes fully accredited, then they would get a permanent license. And if the school does not reach accreditation or becomes out of candidacy, then they would not be able to practice further. But this should address the issue of those individuals coming from programs that are in candidacy for accreditation and will allow us to move forward with those individuals. So we're very happy about that new change. Additionally, the board looked at trying to address workforce with, there was kind of a call to help more individuals enter some of the professions at an earlier stage. And the Addiction Counseling Advisory Committee had recommended creation of a new student temporary license for addiction counseling, which would be for individuals seeking to obtain necessary coursework for a permanent addiction counselor license. It is similar to what was called a counselor in training back under the days of SRS, but essentially this would be an arrangement where someone was still pursuing those classes needing to become an addiction counselor, and then they have an employer willing to hire them under the conditions. And this would be a temporary license. It would only last for a couple of years, but it could be extended for one time if they needed additional time to complete those hours as a student temporary addiction counseling licensee. Additionally, we had heard that some individuals were having trouble passing their licensing examination for some of the professions. And right now, the temporary licenses for the different professions, some of those are 2 years, but most of those last for 1 year. And so to assist with that process, knowing that some individuals may get a temporary license and then something unusual comes up, or they may have difficulty passing their examination. So the change the board recommended that's in the bill is increasing the time for newly issued temporary licenses after July 1st. So after July 1st, we will be able to issue temporary licenses that last for 2 years for each of the professions instead of 1 year. And so we're not able to extend the ones that are already out there, but for after July 1st, we'll be able to start issuing those as 2-year temporary licenses. Additionally, the board was mindful of looking at other creative ways to address workforce issues. And one of those was, as we were looking at the number of new individuals who become licensed, we also saw that there were a number of individuals who were letting their licenses expire. And so when the board was talking about workforce, they were looking to see, could we find a way to help individuals who wish to stay licensed? And so what the board put in language to do was, if individuals are coming to the end of their license term and have not completed all of their continuing education hours needed to renew their license, and they could show extenuating circumstances for needing additional time to complete those hours, they could make a request to the board, and if they were approved, they would still need to renew their license on time. However, they would get 3 additional months of time to complete those continuing education hours. The language in the bill states they would need to show extenuating circumstances for needing that, and they would not be able to request it in back-to-back license periods. Additionally, also looking at workforce, the board knows that there are a number of individuals who were previously licensed in the professions and for one reason or another have allowed those licenses to expire over the years. But we have heard that some individuals may want to re-enter the workforce, but it may be difficult for them to do so right now. For individuals who want to reinstate their license after it is expired, they essentially have to pay double the license fee, and then they would need to have all the continuing education hours from the previous license period. And so what the board recommended was 2 changes. If someone really has been out of the profession for some time, so if their license has been expired for at least a year, they would be able to reinstate their license for half the cost that it currently costs. So instead of paying a renewal fee plus a reinstatement fee, it would just be 1 fee. So it would be easier for people to come back because of the lower fee. And then also the board recommended adding a new 6-month temporary reinstatement license. And this would be for individuals who wish to come back and reinstate their license, but have not completed all of those continuing education hours necessary to reinstate their license permanently. And so they could get this special 6-month temporary reinstatement license, and it would allow them to start working immediately while they're finishing those hours. And once they have finished their hours, they could ask that their license be permanently reinstated. Additionally, I mentioned the legislative committee did make a recommendation, and they put into the bill that the current requirement of continuing education hours for individuals who are able to diagnose and treat. There will be a new standard after July 1st, 2025, which will change the required number of hours in diagnosis and treatment from 6 hours to 3 hours. And additionally, there were some changes in the bill that would change the standard of licensure for licensed psychology. Right now, one of the requirements is having good moral character, but the other professions use a standard of meriting the public trust, which is a more uniform standard with other professions, and it better matches the standard in other jurisdictions. Also, for the behavior analyst profession, there were a couple of really important changes. When those statutes were put in place years ago, they did not match the same language as the other professions. And so for the behavior analyst profession, the disciplinary remedies, if someone were to create violate the unprofessional conduct regulations, the flexibility the board has is to suspend their license or revoke their license, but does not have the same flexibility to issue small fines or perhaps to do a public censure. And so that language was changed in the bill to better sync up with the other professions. Additionally, there was not language in the original statutes that allowed the BSRB to reinstate a license for a behavior analyst. And so the new language authorizes for the creation of rules and regulations to define the reinstatement process. And so the committee will need to work on that language and forward it to the board for ultimate approval. But essentially, this will allow the board to start moving down the path of being able to reinstate some of those behavior analyst licenses after they have expired. There's also a number of other items that involve statutory cleanup, but 3 of the other new items that were added to the bill. One, we had talked at the last meeting about the creation of community-based licenses. These would function similar to the traditional temporary license for most of the professions. When they were originally introduced as an item, as an amendment by the House, these were individuals who would be under the scope of employment by a community mental health center. They would have to be under the supervision of someone at a clinical level license. This would only last for two years, like the new standard for the temporary licenses. This was something that would be applied to the professions of social work for the bachelor's and master's level, marriage and family therapy for the non-clinical level, professional counseling for the non-clinical level, licensed psychology. And then when it was amended in conference committee, it also now includes the master's level psychology profession. And it was further amended in conference committee. So instead of just including the community mental health centers, now it includes FQHCs, it includes psychiatric residential treatment facilities, and then there's also some certain other drug and alcohol facilities that are specifically identified in statute. Another change that was made to the bill before it was passed is there is a new operating change for the BSRB. There is new language that states that within 15 days of receiving an application for license or permit, we will send a message to those applicants, letting them know if their file is complete or incomplete. And if it's incomplete, what else is necessary for us to make a decision on licensure. And then a new requirement that once the file is considered to be complete, we would need to make a decision within 30 days of a complete application. And then there is further language that requires the board in rules and regulations to determine the process by which an individual can have an expedited license. And so that's something the board will be working on in terms of defining that new expedited license process. And then the last change that we talked about at the last meeting, that was a change to the clinical social work statutes and specifically the requirements to become a clinical social worker. The language in the bill specifies that currently, right now, the statute calls for 15 specific coursework hours be completed in the area of being able to diagnose and treat, and that 4 of those 5 classes were struck from the statute. And so it reduces the number of those specific hours from 15 down to 3 hours. And there's also language that has been changed concerning those hours, also the practicum, and then for the 3,000 hours of postgraduate experience. The 1,500 hours currently states that has to be 1,500 hours diagnosing and treating individuals. And now it would state that it would be including but not limited to diagnosis and treatment and a few other categories. Those would still have to be direct client contact hours, but there were some significant changes to the language of those items. And so, as I mentioned when I started this summary, I did want to highlight these items because these are what was included in the final version of the bill. There were a few other items that were originally introduced by the board that were taken out. For example, one item that is not in the bill was a requirement put forward that would have required board-approved supervisors for social work. So that item was not in the final version of the bill. And then there was another item that would have added a new board member for the behavior analyst profession. There's currently not one on the board, but that was also removed in committee. So that's not in the final version of the bill as well. So I realize that there are a lot of different items that I referenced here, but I wanted you to know what was in the final version of the bill that did pass. Just to give you an idea of the next steps, we have been working since that bill passed in terms of sprinting to try to make sure that we can bring forward as many of these items as quickly as possible after the enactment date of July 1st, 2023. We have been holding multiple meetings with representatives from the Board of Healing Arts, and those individuals host our licensing system. So in order to be able to officially issue some of these new license types, we need to have some things done behind the scenes to be able to actually issue those licenses. And so Leslie and I have been meeting with representatives from their office, and we are moving forward on that. And we hope to have that resolved as soon as possible to be able to issue these new items. We've also been having conversations here about creating new applications and adjusting applications so that we can post those on the website after July 1st for individuals to be able to start applying for some of these new items. And we'll be sending out a message to licensees to let them know about these items as well. And then there's other technical items behind the scenes. For example, we utilize a payment portal through another entity we contract with or we work with. And so some of the updates will need to be done there as well. So there's a lot of work behind the scenes to bring all these things and make them live. But we are working as quickly as possible and putting in checks to make sure we're meeting the new standards that are part of this bill. But I thought I would go ahead and pause here and see if you have any additional questions about items that are in Senate Bill 131.
Just to clarify, David, the new category of license that for the community mental health centers and some other entities they added on, that is basically everything except they haven't passed the exam. Is that's so they've satisfied all the requirements to get a regular license, but they haven't passed the exam yet.
That's my understanding, yes.
So in some ways, that's kind of a backdoor way of dealing with the social work exam that they recently revealed has a lot of racial disparities. It's temporary, but because it's only a 2-year license, right?
Correct. It would be a 2-year license. The language in the statute basically says it would not last longer than 24 months. It could be extended for, I believe, up to 6 months under extenuating circumstances, which is a similar language to what you would have for the temporary licenses. But yes, it's a one-time type license. And I believe they added language too that essentially you can't get a temporary license and then get a community-based license. It's a choice of one or the other. So
you can't get and end up with 4 years.
That's not
essentially temporary license. It's one or the other.
Correct.
But that gives somebody 2 years and potentially 2 years and 6 months to deal with passing the exam one way or another.
That's right. Mm-hmm.
David,
or for them to fix it.
This is Jane. So the community mental health license that they're enacting, is that going to be accepted through MCO's billable payer systems? Or will they still not be able to bill from the community mental health license?
That's actually probably more of a question for representatives from KDADS, Department for Age and Disability Services, or KDHE, Department of Health and Environment. I have reached out to them in the past just to make them aware of this, but we don't really deal with the billings directly in our office. And so I'm really not sure. I can't really comment on that.
I think they'll still be working under supervision, won't they?
They will. Mm-hmm.
Right, which doesn't, I mean, that doesn't support the billing piece. It's just like, what would be the benefit I guess, is what I'm trying to get at, of having that if you're within one of these systems that you just named, mental health, federal regulated systems. What would be the benefit of hiring if KDAD says no to making that reimbursement?
Yeah, so this is kind of a technical issue, because essentially, the statute for those new types of community-based licenses, it's one of the items in there that's different from the traditional temporary license. The traditional temporary license includes language to really distinguish that this is a temporary license, and so you can't use the term, let's say, licensed professional counselor by itself. You have to say that you're a temporary licensed professional counselor. The new category of community-based license would say that you can use the term licensed professional counselor without the caveat that it's a temporary license. But I think one of the issues the board had with that was there could be the risk that it could be misleading to the public, in terms of making people think that this is someone who holds a permanent license. And so I know that one of the things that was talked about by the advocates for this was wanting to be able to use the full titles in part to try to get more reimbursements. But I think that would probably come down to those entities that handle that, whether they're going to say, simply by changing this name and statute, now we're going to open it up. I don't know. That's probably kind of a discussion on their end, but all I can say is what the statute now reflects, and then it's kind of up to those bodies to determine if they're going to change the way they handle reimbursements. Because in our eyes, based on the language, it still looks like it may not be called a temporary license anymore, but it's a time limited, no more than 2-year type license. And then there's the statute that says you can use this title. So we're probably not the body to really discuss too much about the reimbursements.
Okay, thank you.
I think we were hearing while all of the legislature was in session that there had been discussions about this reimbursement issue as they were crafting that amendment. So I'm betting there's already been some promises made about reimbursement for that category of license.
Well, and I think I mentioned, last time that we talked, when these issues came up the first time, we don't really have a direct role in the reimbursements, but we didn't really, we didn't feel the board didn't feel it was appropriate to use titles that could be confusing as an end around, if this was the goal. We offered, if we could provide any assistance, to try to facilitate meetings with the individuals who were seeking reimbursements and the groups that were providing those as an alternative. But that was not something that was pursued by, at least they never brought it to us as that way that we could maybe help out in that process. And so we raised the concerns, but they decided to go forward on this. And so we're just kind of trying to figure out where the pieces fall now that it's going to be put into law.
Well, I think there was also some concern that even though they would not be legally allowed to private practice, theoretically, this is a restricted license to only to practice in those settings, that if they're able to use the same credential without a T after it, or, some other designation, that it's not a full license to practice independently, that certainly people could, try to hang out their own shingle and use that credential in that way. Now, it would not be legal to do so, but it would, on paper, it would look legit for somebody that has LSCSW after their name to be able to private practice, or any of the other professions. But that concern was not enough for them to change that designation.
This is Angie. KDHE is the person who's responsible for all the billing. So that's who you would want to reach out to. And then I would probably look at the KMAP website to see if they made any changes on that once this is passed.
Okay.
As another item in the mix, the board does have some regulations that are going through the process of being changed. now that the bill has passed, one of the items too is that the bill sets the statutory cap for some of the fees, and then the specific amount for the fees are set in regulation. So we have put forward emergency temporary regulation, and we have provided that to go through the process as quickly as possible to make sure that because the board had already weighed in on the specific amounts for the fees, but passage of the bill merely sets the cap. It's the regulation. And so as part of that process, essentially what happens is you have a temporary regulation in a situation like this where there's a rush to go ahead and put something in place, followed by a more permanent regulation listing those fees. So that's kind of also something we've been working on here in the office and putting that through. So that is working its way through. And a previous set of regulations has gone through the Department of Administration and is now with the Attorney General's office. So there's a lot of moving pieces right now, but we'll give you updates as we get more information on those items.
Thank you for all your work, and thank the staff. That's a lot.
Well, thank you. I appreciate that. I do want to communicate that I know, there is a goal to get these things out as quickly as possible. I can say that, we're working often on weekends and late nights to try to get these things. We're sprinting as fast as we can. Some of these things are a little outside of our control, but we are doing everything we can to get them out there as quickly as possible. And Leslie has done a tremendous amount of work on terms of those regulations and some of the other language and some of these tasks. I know I'm meeting with certain groups, and at certain times she's meeting with other groups, and the rest of the staff. Yes, they do a lot of work behind the scenes too. We've had little project teams working on just trying to figure out good tracking mechanisms for a lot of these things. So I appreciate that.
Thank you, Jen.
Well, I'll move on to another update. There were two other little bills I wanted to make you aware of. And I probably shouldn't call them little, but in terms of how much I'm going to discuss them today, I don't plan to talk about them at length. But there was a bill that passed, House Bill 2288. It adds Kansas to a multi-state compact for professional counseling. This would be for the clinical level of professional counseling, and that bill becomes effective July 1st of this year as well. However, I do want to kind of pump the brakes a little bit. This is, I think, going to be a very important compact, but it just started holding meetings last year for the Compact Commission. So the infrastructure for this commission has not fully been implemented. So after July 1st, we're not going to be able to issue the privileges to practice that ultimately will be the effect of this compact. The goal is they are hoping to develop the database with all the information and have things up and running, hopefully by the end of this calendar year, or if not, then the start of next year. But officially, we will be a member as of July 1st. At the most recent board meeting, the board appointed board member Laura Shaughnessy to be the counseling commissioner for the state of Kansas, which I'm very excited about that. It's a role I know she was really excited about, and I'm happy to help her out in that role. So she'll be attending meetings on behalf of Kansas and providing updates to the board in terms of that compact. There was also a bill, Senate Bill 66, that was passed that will be creating a license verification portal for all licensing bodies in the state of Kansas. It is meant to assist with being able to verify a license for military members more quickly when they're changing states. But essentially, for some of the entities that did not have an online way to verify a license, it's going to have them provide their information to this new portal. For the BSRB, we currently do have a license verification portal on the website. And so it will mean linking that with this new portal so that they can verify the license on our website or through this new one-stop shop. And so still working out the details on exactly what is going to be required of us, but we'll be working with the Board of Healing Arts, which hosts our licensing database, to make sure we're in compliance with anything we need to in terms of that bill that passed. And then in terms of a few other updates, the board recently met on May 8th, 2023. A lot of different advisory committee members were reappointed to new terms. And so appreciate all of the work you all do as advisory committee members. Those advisory committee terms are 2 years, and each of the members comes up for reappointment every other year. And so appreciate everything you do and look forward to continuing to work with all of you for the next couple of years. The board also received information on proposed unprofessional conduct regulation changes from the different advisory committees. This is a topic we've been working on for the last year, each of the advisory committees was making recommendations on proposed changes to their regulations. And ultimately, it was time for those to be forwarded to the board. And so those were forwarded in a packet. I think you should have about a 60-page packet in your materials for this meeting today. But ultimately, what happens now that each of the committees have made separate recommendations, those combined proposals were being forwarded to each of the advisory committees so you could look through those. And the purpose was to be able to see if you thought a recommendation by one of the other advisory committees could be helpful for you to bring forward to the unprofessional conduct recommendation or regulations of your profession. And I believe when you last discussed your own unprofessional conduct regulations, you were considering some further changes. So you could make any additional changes to your unprofessional conduct regulations, or you could choose to incorporate any of those that were put forward by other professions. And then ultimately, the goal is still to have recommendations forwarded back to the board by the end of this calendar year for perhaps a new set of changes recommended by the board at the end of this calendar year. And then additionally, at the board meeting on May 8th, once a year, the board tries to hold an annual all-day planning meeting. It's usually off-site somewhere in the state of Kansas. Last year, it was in Olathe. This year, I think we're looking to hold it in Wichita. The board confirmed they wish to hold that meeting in person. And this year, it will be on Monday, I believe, October 23rd. And so we'll provide more updates on that as we confirm the location of that meeting. And this is a public meeting, but it's a nice opportunity for the board to meet in different sections of the state once a year and talk about items such as the legislative priorities and different items like that. And then the last item I want to provide an update on in terms of board activities. Board members serve 4-year terms. All board members are appointed by the governor. And there are 3 board members that are expected to end their time on the board. Deb Stidham for the addiction counseling profession. She is wrapping up the end of her 2nd term. And so her 2nd term will end at the end of June. Additionally, Rick Steele for the licensed psychology profession. Rick is ending his 1st term and has some other items he wants to focus on. And so he's chosen to step away from the board at the end of June. And then public member Jonna Norton also will be ending the end of her 1st term and will be stepping off the board. So wanted to thank Deb Stidham, Rick Steele, and Jonna Norton for their service. And the governor will be appointing new members to the board, and we'll keep you updated. Those are expected to be announced maybe sometime as early as this week, perhaps as we get closer to July 1st. But as of July 1st, we'll update the website for the BSRB to reflect the new board members that are serving on the board, and then they will be board members for the next 4 years. Additionally, I did want to provide an update concerning the Association of Social Work Boards, ASWB. I did recently attend an online administrator forum that was on Thursday, June 1st, 2023. At that administrator forum, there was an update on the examination by Lavina Harkless. And she provided some information. They have recently been holding some community conversations and feedback sessions. They are looking at possible changes. One item that they're exploring is a possible alternative to the examination that could be a competency evaluation. But anything such as that would have to be valid and defensible. So still early stages at even considering if that is something that could be pursued, but that is something that at least they're starting to have conversation on. Additionally, they are holding a webinar series with information on the examination and candidate experience. That will be on June 28th, 2023. So next Wednesday, it looks like. Anyone can sign up for this webinar. It's a public webinar. And if you do want to sign up for that webinar on the exam and the candidate experience, you could just go to the ASWB website at www.aswb.org. And then it's underneath the examinations section. And there is an item there that says exams for the future of social work. And they have a section specifically on webinars. But I think if you go to the ASWB website at www.aswb.org and then look under the drop down for the exams, you should see the link for the webinars. And I can go ahead and send an email out to advisory committee members too after the meeting and just provide that link as well. But just to let you know a little bit more about that webinar, The information on the website said that the webinar will focus on recent and future enhancements to the social work licensing examination and the test taking experience. Speakers will share insights into the ASWB initiatives for re-envisioning examinations for the future of social work and administrative procedures, resources, and support ASWB currently provides and is planning to offer. So if you do have an interest in the examination, I think that would be a good opportunity to listen and learn some new information on that. They provided an update that they have launched a new pilot program that is called Test Mastery Mindset, a guided journal for test takers pursuing their potential. And that is a free program that is available to unsuccessful test takers. And it is being delivered by an independent minority-owned group. I think it's to help individuals prepare to take the examination again. And then they provided information about the Social Work Workforce Coalition. They are currently putting that together to provide input on the next round of examinations. They have also launched some materials on their website. There is a free examination resource for educators that includes the data released to schools, the free digital download ASWB examination guidebook, educator guide to the social work examination with group review practice questions, and educator training. And that is on the ASWB website as well. If you search underneath the examination, there's a link that says getting ready for the exam, and then exam materials for faculty. And then they talked a little bit about the practice analysis. So essentially, a lot of the social work examination is based on what individuals are doing out in the field. And so they're putting together another survey of the current social work practices, including what tasks are done and how often, how important things are, especially concerning the area of safe practice. And then also looking specifically of what items should be required from day one. So items that you might have a more seasoned practitioner versus someone who is entering the profession and trying to figure out what is the most important things to test on. They did note that the last census was done in 2016, 2017, and that was the 2017 analysis of the practice of social work. The next census is launching March of 2024. And so if you have any questions on that, that is also available on their website. There were some questions that were asked that I thought were kind of interesting. One of the individuals who was present asked if they could provide an update. There had been some discussions earlier this year about whether states would be moving to not require the examination for their licensees. And so they provided an update. It sounds like several states had either held discussions or had introduced bills on that topic, but very few had actually any movement to make those changes. There was a bill that it was introduced in Maine that would pause the use of the examination for bachelor's and master's, but I don't know if that bill went anywhere. It was introduced very close to the end of their session. In Connecticut, they were discussing the possibility of pausing the requirement for the examination for 2 years, but I'm not sure if that bill moved forward. It was just being discussed. Illinois was the state that had been referenced earlier. They had stopped requiring the test for bachelor's and master's. That was prior to the recent conversation regarding the examination, but they are holding some discussions now on creating an alternate pathway, which would require about an additional 3,000 hours of experience from what I can tell, but I'm still looking into some of the details on that. I'm not sure that's something they've developed or they're just having preliminary conversations, but I wanted to share an update on that, worth looking into a little bit more. Maryland has created a work group to look at examination alternatives. Massachusetts, I'm not sure, they may have had discussions on this topic. In New York, a bill was introduced, but it was introduced very close to the end of the session. So there wasn't, I don't believe there was traction on it this year. Utah was one state that paused examination for the master's license, but Utah is a little unique from what I understand. They had not required passage of the examination up until recently, and there was a lot of pushback in terms of considering pausing the examination but the legislature did go ahead and make that. And then there's been some discussions now about if that's going to be a temporary item or a permanent item. I know in terms of the recent ASWB educator meeting that I attended, one of the concerns was students who were going to school in Utah, that they did not want the examination requirement to go away because they thought that would make their ability to practice in other states more difficult. And so, but the legislature did go ahead and put it in place in Utah. So that's one state that I'm observing. Utah also is, from what I understand, they're looking at whether they can allow for individuals to be able to voluntarily take the examination if it's not a requirement in that state. I'm not sure where that has ended up. But those are just some updates from some of the states that I've kind of tried to look for updates in terms of have they had discussions. But ultimately, I have not heard that there has been a lot of states that have decided to not require the examination or to pause it. It's been a topic of conversation in a lot of states, but from what I've heard, I haven't seen a lot of bills that have actually put that into place. They also provided an update on the social work compact. So I think the last time we talked, they had finalized the language of the compact, but because of how late it was in most states' legislative session, they didn't expect for enough states to pass it this year. From what I understand, the first state that did pass it this year was Missouri. They introduced the compact towards the very end of their session and did pass it. And last I heard, they were waiting for the governor's signature, but I believe that they probably, that has occurred by this point, and they have become a member of the compact. There was legislation that was pending in Ohio, North Carolina, and I believe South Carolina. But given how late it was in those sessions, I would anticipate that probably very few, if any, other states pass the compact this year. But I expect there's going to be several more that will introduce the bill next year and can be discussing that. I do think it would be of value to have a representative from the Council for State Governments come back. And Cynthia, I know that you and I have talked about inviting them to come back and speak specifically to the compact now that the language has been finalized. And so I think that would be definitely valuable. And then the other item we talked about at that administrator forum was the topic of supervision. And on the agenda today, one of the items does focus on the regulation for supervision and the requirements, specifically as it relates to the 45-day notice to provide changes to a training plan. But I think the topic of supervision is getting a fair amount of discussion in other areas. I can tell you that it's my impression there is not a great deal of consistency state to state on what states require under this category. There is a pretty broad spectrum in terms of what states require, whether they require a pre-approved training plan, whether they require modification to the training plan, if they limit how many people can provide supervision. It's just kind of across the board right now. There's a lot of variation. But I did want to let you know that too. I was hopeful that I would be able to talk to representatives from other states, get a consensus on what were the best practices or the most common practices. But as I've attended these meetings for the different associations, it appears that there is a lot of different things that other states are doing. And some of them they believe are helpful, and some of them have, problematic aspects too. And so I think it's definitely worth discussing to make sure that we are having good practices in this, but I can't bring forward a standard to you today and say, this is exactly what we should be doing. So did want to give you an update on that topic as well. So with that, I will go ahead and end my report and I can answer any questions.
David, if they were to pass, if the ASWB were to pass an alternative competency assessment or however they're calling it, would we have to have a statutory change in order to adopt that or to allow that in lieu of the written exam?
I would believe so, because our statute does require passage of an examination for licensure. And so,
but would that not count? I mean, doesn't it say a board that's approved by the board?
Yeah.
So would that not count as, or could that not count as an exam? Does it say a written exam approved by the board? Does the statute specify written?
I'm not sure of the exact language on that. I believe it does say though that it's a national examination. So I think if it was something that was just relating to hours of practice, I don't I don't think that would meet the standard of an examination because that appears to be a different topic. But I think it's definitely worth looking into. I do think one of the things about a standardized examination is they can have it vetted by outside companies to make sure that it is, defensible, and they can look to see, is there variation in different things. I'm not sure if that process would work the same way for an alternate competency type evaluation. And this is very very new discussion on this, so I don't really have a lot of details on this, but I thought it was interesting, just as something that some people are starting to talk about, but I don't have a ton of details on that yet.
But in what discussion you heard, it was just going to be an assessment of their experience. It wasn't going to be an actual examination of that individual and their, like some kind of a role play or something where they would demonstrate how they would handle a situation. It was going to be just an assessment of their hours.
I'm not sure. I may have only heard a piece of it. They made reference to it, but it didn't sound like, it wasn't a fully fleshed out model. It sounded like, and I wanted to bring it forward as something that I have heard, but definitely not something that has been fully developed that I can kind of walk through. But it did sound like at least one of the items they discussed as part of that might be an extra 3,000 hours, but I'm not sure if that was something that was being talked about as a possibility or if it was a real concept that they were actually looking at. So.
Okay, thank you.
David, in your meetings, did you hear anybody talk just specifically about the clinical licensing, since they're already required to do so many hours in practice? That's the one that I'm most interested in, because I do believe we need something for competency or exam at the foundational level, a bachelor and master's going into it. But the clinical has already been practicing, and they have so many additional hours that they have to provide to even apply for licensure at the clinical level. Has anybody specifically talked about that?
I don't recall any recent conversations on that. Most of the conversations have kind of focused on the discussion of should it still be required for the bachelor's and master's, but I haven't heard anyone talking about it for the clinical level recently.
Thank you.
Any other questions, comments? Okay, thank you, David, for that extensive report and update. We'll move on now to old business. And the first item under old business today is a continued discussion on possible regulation for care of clients in crisis. And what we've been discussing is the idea of referring a client in crisis to the ER or to the 988 hotline versus answering that crisis call ourselves as practitioners. And we hadn't reached any consensus about what was the appropriate way to handle a client in crisis. I had a thought that maybe the language, this is part of the unprofessional conduct language. Maybe it could say something about it would be unprofessional conduct not to have a plan for appropriate care for a client in crisis. That's kind of a cop-out because it doesn't specify what that appropriate level would be, but it puts it on the practitioner to determine what is an appropriate level of care for a client in crisis. What does anybody think about that? Or does anyone have another idea about what we should say about appropriate care in that situation?
I have a question. So if I was seeing somebody in as a consumer, and I might have suicidal tendencies and you're treating me, what is the normal procedures that we are seeing that's in place now? Is it where they're at the time when you first sign that person up, are you supposed to provide crisis information in the event that you're not, like in a private practice setting versus like a community mental health practice? I mean, what is the, professional standard that we have right now?
I think it varies is the problem, but my practice statement included a long list of crisis agencies that clients could access. And I also always carried a pager. I understand that's no longer the norm for most practitioners, but I always carried a pager so that I could be reached, at any time. Most practitioners don't want to do that. They want to have more boundaries around their hours. Some practitioners use a answering agency that will take the call and then notify them so that they can decide whether and how to respond. But they put that answering service in place between them and the client for a crisis call. What about any of you that are doing private practice? What's your standard for crisis care?
My standard is that I want the client to reach out to me, and then I direct them to emergency services if needed through the ER or into a community mental health center that has a crisis center to seek treatment if I'm out of office. And it's in my business practice.
Right. In your practice statement. So your clients know that's your policy from the beginning. And have you?
I say I do the same thing.
And do you both find?
I was to say they have my cell phone number, and they can reach out to me, and then I can help attach them to services as needed.
And do you find then that if they reach you directly and you refer them to one of these other agencies, do they follow through? Do they go and seek that care?
Typically, yes.
And how about you, Jane?
Yes.
You find that true? Okay. So you both are able to be reached directly by your clients.
Mm-hmm.
But then if it's after hours, you refer them to some other specific crisis.
Mm-hmm. I want to know if my client's in crisis. And so I want to be the first person to contact. I don't know if it's a control issue or if it's just being aware of what's going on so I can follow up with care. Yeah.
I think it's part of the care that we are promising or agreeing to when we take on a client. And I found that many times just talking with a client in crisis on the phone was sufficient, and they didn't need to go for additional crisis care. So I guess the question in terms of our unprofessional conduct guidelines is, do we want to say that clients being able to contact us directly is when they're in crisis is a standard of care? And then from that point, it's the practitioner's discretion as to where they might refer that client.
I think that's probably asking a lot. I really did like kind of the initial language you use, that it's really the practitioner's decision to make their policies and procedures around crisis kind of their own responsibility. I mean, that's sort of the job of being an independent practitioner, is to have those things in place.
True. Absolutely. And I think there's already, some of the informed consent language, could be construed to cover that. But do we want to set any kind of a standard beyond just making it saying that it's unprofessional conduct not to have a clearly stated policy for what happens if a client is in crisis.
Can I just ask
Angie.
one more thing?
Sure.
So what happens if you're seeing a minor, and like we deal with kids that are runaways or different situations, but they're still, or maybe they're not under care per se, but we still want to make sure we're seeing them. Is that going to be when they sign a contract? It's not them it's signing, it's the parent, correct? So
Right.
how do we differentiate those kids, those situations where we need to make sure that those crisis is communicated, I guess, is what I guess my concern was. But that was just me throwing in something, but sorry.
So you mean that the your stated policy, if you're dealing with a minor, would need to include informing the parent? Is that what your thought was?
Informing the parent as well as the child where they can reach out in the event that they're not with their parent in a crisis, I guess.
It gets to be a little slippery slope there, because what determines a crisis, and then some of the other legalities of informing a parent, sexual assault, some of the things that, they may seek treatment at the hospital for. Yeah. I guess signatures in the very beginning when you take that client on, it should be, again, in that informed consent.
Do you think, though, that's what I'm asking, do you think it's also shared with the child and the parent together, or is it something that you make sure that they sign off if they can sign as well, so that that they understand? I mean,
in mental health treatment, isn't the age of consent 14?
I hadn't heard that, but I've worked with a lot of adolescents. I always assumed that I always understood that parents had to authorize the treatment. But, my concern about working with the adolescents and a crisis situation, you might have a kid that's not out to their parents and they have a crisis. And so what's your responsibility as the therapist in informing the parent of the crisis without necessarily sharing that if the child isn't ready to share that information with their parent?
yeah, I'm looking to more like crisis, thinking of suicide and things like that, I guess.
Right. That's what I was thinking. The kid's suicidal because he's being bullied at school, because he's out, people are teasing him or whatever. And so you have to parse that, the child's privacy with the parent's right.
Right. And you have the law under harm,
Okay.
So would it be appropriate to add a phrase if we're going to say it is unprofessional conduct not to have a clearly stated policy about how clients can access crisis care, that it has to be in accordance with existing laws regarding sharing of information?
I agree with that. This is Lee.
To add that phrase to it?
Yes, that sounds good to me.
Okay. So I'm not hearing that anybody thinks that we should have a more specific standard than leaving it up to the practitioner to develop that, or to have a clearly stated policy that their client is informed of at the beginning of service. And just leaving that up to the practitioner. Anyone disagree with that? Okay. And everyone okay with adding the phrase about in accordance with existing laws regarding privacy, or I'll work through the specific words on that and send it to you.
That sounds good to me, because we'd have to go compliance with HIPAA as well. So that would cover that.
Yes, yeah, true. And it also covers then if some of that law may change. Instead of saying specifically what it is, if we say in accordance with existing laws, then that
That's
covers us if and when those laws change.
right. And we won't have to change it. We won't have to meet again or get them changed again. Is that right?
Right, right. Okay, all right. Moving on to the second one, under old business, continued discussion on changes to the clinical training plans. And this was the issue that David mentioned earlier about the board has had to deny a number of hours of practice hours several times in the year I've been on the board, because people did not inform the board when they changed their where they were working, where they changed supervisors, or there was any significant change to their training plan that had been approved. In a couple of cases, it was just that they changed locations with the same agency. They still had the same supervisor, so we were able to let that through. But they're required to notify the board within 45 days right now. And if they don't, and they continue on in their new position with their new supervisor, and they've never updated their training plan, then they lose. Well, they go to get licensed, and they lose sometimes, half their hours. I think the last one we did lost, a third of their training hours because of this issue. So the question is, how do we, could we change that to that would allow a little bit more space for people not following that guideline? Part of the issue is that the supervisor's supposed to know about that and supposed to tell the supervisee, but it's ultimately the supervisee's responsibility to also be aware of those. And they sign, when they submit their training plan, they sign, saying that they've read all those rules and regulations and they know what they're supposed to do. But I remember one of the ones we denied the change had happened during the pandemic. And the supervisor said, well, it was pandemic, and it just basically it slipped her mind to remind the client that they needed to, or I'm sorry, the supervisee that they needed to submit an amendment to their training plan. So even if they know about it, they don't necessarily always do it. So what ideas, how could we change that to allow some room? David, did we talk about some specific language that we could insert or change that to that would give us more wiggle room on that?
Yeah, and just kind of for reference, this is the supervision regulation, like you mentioned, it's KAR 102-2-8. And in that regulation, the specific part that talks about the 45-day requirement needing to update the board about changes is in item number 7, which is the very last item in that regulation. And that item says all changes to the clinical supervision training plan shall be submitted by the supervisee to the board for its approval. These changes shall be submitted no more than 45 days after the date on which the changes took effect. If the supervisee fails to submit the change to the board within that 45-day period, no supervised hours of practice shall be accrued or credited for any practice beginning on the date the changes took effect through the date on which the changes to the plan are approved by the board. And just like what you mentioned, there is a question about, what is the ultimate goal of our regulations, and does this particular regulation still function the same way to make sure that we're getting what the board is desiring in this regulation? And ultimately, we want to make sure that people are providing services in a way that is consistent with law, and that they're doing it consistent with the training plan that's been approved. And so I think the reason why this may have been introduced in the first time is that if people make changes, we don't want them to waste all the time that they might have accrued after making that change.
Right.
And so this was, I think, put in as a benefit to those applicants to make sure that they have a penalty so that they know that they need to report things back to the board to make sure those can be reviewed and verified that they would still be items that they could accrue time for. But as Cynthia mentioned, when individuals fail to follow this regulation, they can lose a significant number of hours, and that's not just the time, but also the cost. And in terms of some of the specific alternatives, instead of the phrase all changes, some of the other advisory committees, because each of the advisory committees for the board is asked to discuss this and forward recommendations back to the board. Some of the other advisory committees have talked about changing all changes to all substantial changes to the clinical supervision training plan shall be submitted by the supervisee to the board for its approval. And then having some language that would say including but not limited to, and then listing a few things specifically right there. And I think some of the items that were discussed by some of the other advisory committees, I think a change in supervisor, a change in work responsibilities, that kind of thing. And then I believe there was also a discussion about change in location, if that was one of the items. But ultimately, you know, this would not have to be a comprehensive list. It would, one of the goals, I think, in listing items here is that it would be, you know, definitive
Examples.
in these instances, right? And so provide more visibility for the people who were needing to submit those changes, and then also for the supervisors, because they could be aware of that and say, oh, well, if I see this, I need to let them know they have to do this. And then also there was a discussion about the role of the 45-day requirement. Right now, there's pretty strict language that says if the change is not submitted within the 45 days, that person loses all the hours they accrue after that point.
Mm-hmm.
And so some of the other advisory committees have discussed, instead of saying the board shall, you could add some language that said, if a change is not, provided to the board, those supervised hours may not be counted if they're inconsistent.
May instead of shall. That
Mhm.
gives us some discretion on the board.
It would mean the board would be reviewing more of these cases if they fail to submit them. But it would give the board some flexibility to weigh if there was a real substantial change that wasn't reported, or different factors like that.
I guess I would say instead of location, a change in agency, because some people may just be working in move to a different location within the same agency. So physical location isn't so much the issue as I don't know by itself in terms of it being substantial. But I like the idea of saying substantial, not all changes, and including but not limited to, and giving a couple of examples like what you just described. What do any of the rest of you think?
I like it as well. This is Lee.
Thank you, Leanne. Anybody else have a thought?
This is Kristen. I think that is a good idea, especially for people who are working in bigger agencies. I like that wording.
Okay, great. Anybody else comment? Anyone think that we shouldn't loosen that up in this way? Okay, great. I think we can come up with a specific wording similar to what we just described, and I'll shoot that to all of you after our meeting. And then the last thing under old business was continuing education and documentation for continuing education. And David, can you tell us what the issues are on those two?
Sure. And just before I forget, Cynthia, since you mentioned you were planning to send something out to the advisory committee members.
I'll send it to you, right?
Yeah, go ahead and send it to me. We just want to make sure we don't have any discussions by email outside of a meeting, but
right.
If you send it to me, we can always have one-way communication that I can just send things to think about for the other members of the committee. So I'll just go ahead and forward that after you send it to me. So
will do. Okay.
Yeah, so on the next item, that is So we have been essentially asked by the legislature, not just us specifically, but all agencies, to make sure that we're reviewing our regulations, to make sure the language is still appropriate, that we don't have outdated regulations, and to make sure that we know, the purpose of the regulations is to help us implement existing law. And so these are a couple of regulations: KAR 102-2-4A, continuing education for licensees, and KAR 102-2-5, documentation for continuing education. And the continuing education regulation, and the last time this was updated for your profession was back in 2003. And the documentation for continuing education last time it was updated was 2000. So they're definitely good for review. These regulations, essentially the first regulation talks about what needs to be obtained for the purpose of continuing education for your profession. In statute, it outlines the 3 hours in ethics and currently the 6 hours in diagnosis and treatment. But the total number of hours, that is just in the regulation. So that's one piece that's included in this regulation. But also in KAR 102-2-4A, it lists a number of different items or topics that could qualify for continuing education. And as you might recall, we had a discussion a few months back about amending this regulation to add being able to accrue a certain number of hours for providing coaching or mentoring for people who were taking the licensing examination. So that is one of the changes that's currently working its way through. But one item you could look at in terms of a possible modification to these regulations is if you feel there are any other items that you think would be helpful to have added to the regulation. If there's any items that are currently included that you believe have some confusing language that you think could be clarified to help people understand better what they might be able to use to get continuing education. And then also, there's any outdated references to technology or anything similar to that in either this regulation or the accompanying one, the documentation for continuing education. In some of the regulations, there were some references to things like videotapes and cassette tapes, and not really as commonly used as they might have been in the past, but maybe, video recordings and audio recordings, just kind of making good common sense cleanup in terms of that too. So as part of this, I did go ahead and try to do a little bit of research first on the topic of total continuing education hours. So for your profession, for every 2 years, licensees need to accrue 40 hours of continuing education. I did some research on the different totals for states, and what I found was that there is some variation, as to be expected. Some states have a 1-year license period instead of a 2-year. I think there's a couple of them that have a 3-year license period. So I tried to prorate it to see what it would be equivalent to a 2-year license period. But essentially, if you look at different states, the most common standard of continuing education requirements for continuing education hours for social work is 30 hours every 2 years. And there were 18 states that had the 30 hours every 2 years. The next most common was 40 hours, and there were 15 states that required 40 hours every 2 years. And then there were some that kind of fell in between. The highest state had 45 hours every 2 years. So in terms of our geographic neighbors, Missouri requires 30 hours every 2 years. Nebraska, I believe it's 32. Colorado, 40 every 2 years. And then Oklahoma has 16 that they require every 2 years. So.
Well, and just for historical perspective, it was 60 originally for LSCSW every 2 years. So it got dropped to 40 some years ago. I'd be fine with dropping it further as, again, another way to help people stay licensed.
So are podcasts right now considered a way to get CEUs? Because I know NASW does podcasts now.
Podcasts are not specifically listed in the regulation, I believe. Is that correct, David? But that's one thing that could be added.
I'm not
And-
sure about this, but I would guess that perhaps podcasts maybe weren't even in existence back in 2000.
Right. Yeah, I looked at everything that was listed, and there's a lot in there, but I don't think podcasts were a thing yet. The last
Well,
time these regs were
I
looked
think-
at.
Are they given continued education credits for those podcasts?
I think it would fall under the, like mini, what is it? Mini course or something like that, you know, I don't know. I
It
don't
would
know.
fall under self-study, like reading.
Yeah,
Mhm.
'cause it should, because as long as they're NSAW is supplying CEUs for those, I think they should be. I would say they should be usable.
Well, and-
Well, it's how would you document that though? I mean, if a podcast is set up to send you a certificate of attendance, but I don't think most of them are. Maybe the NESW ones are.
I would think they would be, because if they're offering CEUs, because if they don't offer CEUs, then I don't think they'd be usable.
Well, you can read something and get credit for it, but there's a limit on the number of hours. I think it's 10.
Right.
Is that right, Leslie?
Mhm.
Yeah, 10 hours that you can read something without having a pre or a post test. But for the rest of it, does require some kind of post test or documentation.
And when it talks about the CEUs have, or those like readings and stuff, do we have to have them approved then by the board, all the journals we read?
I don't think you can get them pre-approved, right, Leslie? You just
Right,
have,
we don't pre-approve them. What happens is if someone's audited, they list those in their CEU reporting form. And then they would be approved or denied at that time. If they were done in good faith
Mhm.
and we feel that they don't meet, doesn't appear to be social work related, then we would have the person make up however many hours that was.
I just,
and
I just, I don't know what that is, but
Sorry.
I was just wondering too, though, when we do self-study, like even now, like when we have to read all this stuff we need for like Senate bills and House bills and that kind of information, is that in addition to the hours we sit on a board? I mean, I don't know how that kind of plays out too, if that maybe describing some of that in more detail be helpful as well. I don't know.
well, you get 6 hours a year, I believe, for serving on the advisory committee or on the board.
Right, and we do that just by attending the meetings, not all the other.
Right. Right. So I don't know, Leslie, has anyone ever tried to submit for all the reading and prep that you do for these
No,
roles?
I mean, I would think that would be part of serving
be
on the
included.
committee.
Yeah, okay.
I just wondered, just kind of.
It's minutes that you spend for sure.
Yeah, but these are good topics for conversation, because if there is something where if someone was just reading through this regulation, you know, would they be able to understand if something qualifies or if it doesn't? And so those could be potentially changes too, to help people better understand what might qualify.
Yeah.
Leslie, do we have very often people submitting things that don't get approved when on audit?
You know, honestly, some, but not a huge amount. The first time audit for LBSWs can often have things like from DCF that are specific to their job and not just social work related. But we allow them to make them up. But other than that, just a few, not very many.
So you don't see evidence of like a large amount of misunderstanding of what is allowed at this point,
No.
other than for those first time renewers at the bachelor's level. Well, that's good. So that probably means most people can read and understand what's there, but we definitely would want to add maybe a reference to things like podcasts and take out maybe some outdated ones.
Right. And we do.
Somebody-
I mean, even though there aren't many that that are denied, we do get a lot of calls asking for information about, will this count? Will this not count? We can't pre-approve, so we just try to,
Item.
yeah,
Yeah.
make them think.
So when they ask if things are going to be approved, is it because of the content of what, or is it because of the modality?
Both. Content a lot.
More content than.
Yeah.
Because you'd
So,
be surprised how many work-related things that we have to do as just a generalist social worker, that like Medicare, Medicaid trainings, and understanding more about how the systems are and how that relates to, Kansas citizens, and what they can seek out for resources and things like that. There's a lot of educational opportunities also with, community-based resources and information that's kind of shared in a training setting, so more people are aware of how to help people. And I don't know if that really covers that under this, but I think what I heard Leslie saying is people call and ask about that, like with DCF, like child endangerment, seminars and things like that. Even though it might be work related, it's also general across the board how to be a better person who knows how to report, and send information for child welfare issues or things that you come across. I mean, some of that stuff can be relatable, and that's why it's kind of a gray area, because there's really a lot of things for a social work practice person who needs to kind of be reminded of, their task as a social worker and being on the front lines and what we need to do as well. So, I can see why they call. Yeah.
Well, all social workers are mandated reporters, so I would think
that's what I'm saying.
a training about that, could be arguably enhancing social work knowledge. Likewise, Medicare, Medicaid, and community resources, because in any social work role, you might be called upon to provide resources or to steer someone.
Like car seat safety, how to fill out this form, how to testify for DCF, things like that are really specific to what they're doing in their job.
Okay. So, and I think there is a phrase in the reg, if I remember correctly, that very specifically excludes trainings that are specific to your job.
Yes.
So that's already in there, but I don't know if it could be clarified any further. Do you think Leslie, that there's any rephrasing of that would make it more understandable for people?
I don't know. Because to me it's clear, but
yeah.
But I'm not in that position. I'm in this side where I see it all the time. So
yeah.
That was why I was saying, if it's doing those other general practice things that social workers have, that shouldn't be considered just because it's job related, that it's not pertinent to the social work profession, because we're working in that profession as well. That's what I'm just saying. I don't know. I'm not saying I want to claim hours, that aren't useful, but I still feel like there are things that, employers are starting to do a better job of continuing, updating people with their policies and what needs to happen, and kind of how things are happening across the board in Kansas. And so anyways, I just think that it could be doctored a little bit in that phrasing. If it's social work based, maybe instead of just job related, because we do jobs in social work. So anyways.
So you're saying you think it could be more clearly defined what only related to your job is versus broader social work. Do you have a phrase in mind that you think could be added that would clarify that further?
Maybe
than what's there now?
Maybe if it relates to the ethics that we have to uphold, maybe.
Well, we're already required to do 3 hours of ethics.
No,
so there's no question.
I meant about the.
Maybe we could start with the language of what's not allowed, and then we can kind of clarify from that. So
yeah,
that would be in item number F. Approval shall not be granted for any of the following. And item number 3 states in-service training if the training is for job orientation or on-the-job training or is specific to the employing agency.
Where's that at?
Specific to the employing agency would preclude then if it being more broadly applicable. So like what you were saying, Angie, about the applicability of Medicare, Medicaid training or community resource training, et cetera, that wouldn't be specific. That wouldn't be specific to any agency, even if it was offered through an agency, right?
Mm-hmm.
Right.
So I think that would be approved under that statement as it is. Yes, Leslie?
Yes, it would be.
Yeah.
I'm just thinking back to all the hours that is required in a mental health center. And not all those hours are applicable to
Licensure renewal.
my licensure. Yes. And I recognize that. I mean, we ask for 40, but I probably have 80 to 100 in a year's time.
Mm-hmm.
And I recognize I have to figure out which ones are going to be applicable to my license versus my employment. And there is a separation. And I would say most everybody in this field is in that same situation.
Mm-hmm. Yeah. Does anybody think we should lower the number of hours?
I think we continue to lower, and I want to uplift us and not, reduce.
The quality.
Yeah.
Anybody else on that topic?
But if we do the
Hours?
interagency agreement or compound, whatever.
Compact, interstate compact.
Yeah, and if they all are doing 30 and we're not, how is that going to relate, I guess?
You mean if they're doing 30 and we're still doing 40?
I believe it would come down to what you're required to do in the state where you have your home state license, essentially. The way the compact is set up is that you could either, once that's all developed, so you could either buy a single state license. So if you're licensed here in Kansas, you could just buy a Kansas license, or Kansas would be issuing multi-state licenses. So you'd be able to practice in Kansas and the other compact states with that. And so you'd be required to do what Kansas requires in terms of continuing education.
Yeah, and I don't think that the number of hours of continuing education was part of the interstate compact requirements. So it wouldn't matter if one state had a different standard for that than another. Is that right, David? Is that what you remember?
Yeah. There may be some requirement that you have continuing education in your state, but they don't have a certain number of hours for that.
Yeah. The bigger issue with that would be the exam for any state that decides not to require the exam. That is a part of the interstate compact that you have to have passed the exam in order to get an interstate license. So that would have to be addressed for any of the states that decided not to. And we don't know yet whether individuals who were licensed in a state that did not require that exam could take it on their own and then be able to qualify for interstate compact. That's one of the questions we'll ask if we can get the Council on State Governments to come talk to us about the final version of the interstate compact.
So David, you mentioned F. Where's the F? Which one are you looking at? The 102.4A or the?
Yes, so this would be 102-2-4A, and then it's a little hard to follow the legislative style, but it starts out little a, little b, and then as you keep going down the document, on the last page, towards the top of the last page, there's a little F that says approval should not be granted for any of the following, and then it lists 4 different things. So it'd be a little F3.
Thank you.
So do we want to try to clarify that in any way, that specific one about work-related CE that is specific to your agency versus to relevant to broader social work knowledge? And if so, is there a phrase someone would suggest that would make it clear?
Could they just include the syllabus maybe of that course?
Oh, do you ask for that to
If they
determine?
got audited, I mean, I don't know. So then,
So if someone's audited, they have to send the certificates. If the certificate is not clear to us that it was social work, then we would ask for additional information.
okay,
And which might include the syllabus, right?
Mhm.
Okay.
that's what I was thinking. Okay.
And what about on the documentation then? Was there something that is not, some form of documentation that is not currently included as we're looking at updating, David?
Well, so
I
I'm
mean,
thinking,
we've got.
yeah,
Sir,
in terms of just some updating, I would think in 102-2-4A, item 4, item E4 and E5 both make references to videotapes and audio tapes. So we could change those to video recordings and audio recordings. And I think it would take care of those if they're still using audio tapes and videotapes, but it would also apply to things more broadly.
and should we include podcasts in that as
Wouldn't
well?
that be considered audio or video, a podcast?
I
If
think,
it's video,
yeah, I think it would opening this up that way and not having it tapes but recordings. I think
That could be interpreted broadly, yeah.
Mhm.
Any kind of, okay. That's under the CE requirements.
Mhm. Yeah, and then on 102-2-5, item J talks about what sort of information you would need to provide, and item J makes reference to videotapes and audio tapes as well, because it calls for the activity date when video tapes or audio tapes were utilized for continuing education purposes. So that could just be changed to video recordings and audio recordings.
Same way.
Same way.
Mhm. Well, those seem like simple changes to make that would bring us into the current era of how we're getting our CEs.
For now.
Yeah, for now, until the next technological advance, right?
Yeah. And Leslie, I know some of the other advisory committees have talked about item number E7, the self-directed learning project. Do you mind commenting on that?
Yes, so that has been in the regulation since I started. And I've only, I think, reviewed 2 or 3 in the whole time I've been here. And there's really no supporting information or documents or regs or anything to tell us what should be included, what anything about it really. It's just and so the other professions have been considering removing that from the regulation, that they felt there were enough ways you could get your CEUs, and so they're just removing it.
I mean, essentially reading something or
Right.
watching something without a pre or post test or whatever could be considered a self-directed learning project. So it's probably redundant even to have that in there as a separate category.
Right.
So I'd be in favor of eliminating that.
Mhm.
this is
I think
Leah.
it's too suggestible.
Say again?
I think it's too suggestible.
Yeah, it's not very clearly defined. Leslie, the ones that you did review, what kind did people provide, like an outline of what they'd studied, or just tell you the name of a book they read, or what was it?
There was in the very, and this was in like 2000 and something, there was a group of people who were, I think, reading about a modality, and then they were getting together and discussing it, and furthering their knowledge about it. So it was reading, but they were doing additional things with it that
Like a group,
Mhm.
almost like a book club or a group
Right.
discussion. Yeah. Well, I think that kind of activity would fall under the other things categories that are listed anyway, right?
Yes.
Well, what if someone decided they wanted to put together like a ethical training kind of recommendation to do across the board for, continued ethics or something like that. And so they wanted to kind of help the profession, and by doing some kind of active learning process. I mean, I would think that would be more kind of what that was kind of looking at to me, is if there's some kind of, especially with the diversity situation and some other things. But I still don't think people would actually use it as that. But I could see it more as if it was trying to, educate across the board the state of some type of progress. And
Well, I think if you as the individual social worker were presenting that's already in there also
as a
as something that
presentation,
you can get credit for both your preparation and the first time that you present the course or the class that you've created. So that's already in there under a separate category.
Yeah.
We could just
I
redirect them
agree.
to that.
Yeah, I think that person should go ahead and whether they apply or just facilitate a credential of a CEU for that, not credential, but CEU for that, and sign it,
And so,
saying that, they're responsible for that.
yeah.
We do that now.
Yeah. Okay. So does anyone have an objection to removing the self-directed learning project as one of the ways to get your CEs? Okay, great. And is everyone okay with what David suggested about changing tapes and videotapes and cassette tapes to video recordings and taped recordings to just update our language?
Yes.
Yes.
Okay. Hearing no objections, let's go ahead with those changes. And now, if everybody's good with it, it's almost 11. Would everyone like to take a 10-minute break before we come back to finish up? Everyone okay with that?
Yes.
Yeah, I'm all right. This is Lee. If my client actually arrives, I will have to be signing out.
Sure. Okay. All right. I've got 10:58. So let's come back at 11:08.
Okay, and I'll just to let everyone know, I'll put you in the waiting room, and so I'll let people back in at 11:08.
Okay, great. Thanks, David. failing to.
Thank you so much.
Okay, I think I've let everybody back in from the waiting room now, so.
Okay. Welcome back, everyone. I was working, just trying to put down what we discussed at the beginning about crisis care. So just wanted to run this by you all. It will be unprofessional conduct to fail to maintain and provide to the client a clear, appropriate plan for managing any need for crisis care. Does that sound like what we were all agreeing to earlier?
Mm-hmm.
Anyone have an idea of word change? Or I'll send that to David and let him send that out to you in writing. But I think that was what we were talking about, because we need to both make the plan and provide it to the client as part of their informed consent. Okay, moving on to our next topic, new business. And this kind of falls under that, what I just was stating, a discussion on unprofessional conduct regulations. And David gave us, I believe it's 42 pages, David, of all of the unprofessional conduct regulations that the various professions under the BSRB have come up with. And the one that we have been talking about, and this didn't get listed on the agenda, has been the one about how long after ending a relationship with a client it should be considered unprofessional conduct to have a sexual relationship with them. So I went through all the different professions said in that unprofessional conduct, and the licensed psychologists say that it is inappropriate for anyone who has ever been a client, period. Professional counseling changed theirs from 24 months to 60 months, 5 years. Addictions, MFTs, and master psych stayed with the 24 months. So in addition to what they're proposing in their unprofessional regulation changes, I also looked at a bunch of different codes of ethics. And David, do you have the ability to let me share a screen?
Let me address that. Okay, now you should be able to share your screen.
Is there any way we can put ourselves on mute when we're not talking? Because I'm getting a lot of reverb.
Yeah.
Thanks.
Sure.
That's great. Okay, let's see if this will work. Oh no. Oh, I gotta do share. Well, I'm not showing the share on my taskbar. Oh, there it is, share screen. Okay. And it's gonna be, there we go. Okay, so at the top is what I came up with after looking at a lot of the other codes of ethics, because the psychologists in their code of ethics, even though licensed psychologists in Kansas, their unprofessional conduct regulation says never, in the code of ethics, they allow that if they do engage in such activities after 2 years, after following termination of therapy and having had no sexual contact with that client before that time, that it's on them to demonstrate that there has been no exploitation. And they give several criteria here to be looked at to help determine whether that client might be being exploited. American Association of Marriage and Family Therapists says sexual intimacy with former clients or with known members of the client's family system is prohibited, period, even though the unprofessional regs allow it after, or just say 24 months. Let's see if I can roll down here to the other one.
No. No. It's not letting me scroll. And then
It's on
the
the
next
right-hand
one,
side. There, that dark bar, you just pull it down on the right-hand side of the
Yeah.
screen,
yeah, it doesn't have it.
on the very right. Keep going over.
I've got green instead of dark. No, that's the bigger screen. Oh, yeah, I see. I gotta shrink our. There we go. Now I can do it. Okay. American Counseling says 5 years, and addiction professionals also say any current or former client. And I noticed also that several of them mention not only the former client, but anyone related to the former client. And I don't think our current regulation says that. So I'm gonna stop sharing now. But so what I came up with was, it shall be unprofessional conduct to make sexual advances toward, engaging in physical intimacies or sexual activities with, or exercising undue influence over any person who within the past 24 months has been one's client. If such a relationship is formed after 24 months, it's incumbent upon the social worker to demonstrate that the former client is not being exploited or harmed. And I guess I should have added former client or person related to that client. And some of them also include supervisees. I don't know if we feel like that should be included as well. So feedback.
Just some semantics. I would put has been a current or former client, something like that. And then instead of incumbent, I think I would put the responsibility of the social worker.
Okay.
I would make it a little bit more lay term. So it's very clear what the responsibilities lie upon the social worker.
Sure.
And we do
And
have,
the former client is not being exploited. So we do have former client there, former or current client is not being exploited or harmed.
There's already a separate one for current clients.
Oh, okay.
Yeah, that says that you
Okay.
cannot have make sexual advances towards or any of these activities with a current client. But then there was a separate one about former clients
Okay.
that went to the 24
Got
months.
it. So the about the family, that's really broadening it. I never even considered the family being, conversation on this. I don't know how I feel about that, because that starts to really broaden the horizons of this scope. What we're
I was
aiming
thinking
for.
the same. I was thinking the exact same thing. Like in small communities, that would be tough.
Mm-hmm. And what does that mean? I mean, how far out do we go on that with family?
I think that some of the other professions specify it's like immediate family members.
Well, and I think I understand why a marriage and family person would have that piece in there, because they're doing a lot of systems work, and you can't just say, hey, this person was the client and the other 4 or 5 people doing the systems work were not, so they're free game. I think I understand why a marriage and family would include that. I don't know if we need to.
American Counseling has it in their ethics. And so does addictions counseling.
Social workers, I mean, we do family counseling. We're definitely encompass of a lot of different modalities.
Mm-hmm.
I don't know. But I hear what you're saying, Eric.
Yeah, it would have to be pretty closely defined if we were going to add that. If you work with an individual and you never see any of their family or romantic partners or whatever as part of their treatment, Seems like there would be
And maybe
less
that's how we
rationale.
define it, as a family or working within a
With an individual, but of
or
course,
group. Right. Yeah. I'm trying to think of the wording, but yeah, maybe that's how it's defined. So it does talk about what Eric just stated, you know, within the marriage and family, the systems work. Because you're right. Who's your client there? We have a client that we identify that's basically identified for reimbursement. But then you have 2 or 3 people in here
mhm.
that is a family systems. And
Well,
that's
at the point,
restricted information.
but at that point,
It'd be
whether
nice-
whether you billed under those other people's names or not, they're your clients. So that would fall under them being your client automatically without you saying that because they're related to the identified patient, merely because they're related. They become your client for this purposes of ethics, even if you aren't billing under their name, right?
Correct. But in my estimation here is that, so how do you gather all this information? We've been talking for the previous couple hours about making things easier to get into practice, and here we are, something, you know, how many generations, how extended of the family. I think there's a lot of pieces to this that I'm not sure we want to add or tackle. I mean, I really think if you're in practice with somebody, I don't know, I think you're extending this to a point where I don't know if it's even going to be realistic to try to track down.
Well, it would only become an issue if there was someone that felt that they'd been harmed or exploited as a family member of a client, and then they would have to be able to demonstrate how that happened. But I hear what you're saying. It does open up a whole can of worms about how you regulate that, how you decide what's a close family member or what's the former romantic partner of the client.
Well, and the converse of that, how do you say somebody isn't a close family member without disenfranchising them from their family? Let's say you chop it at first cousins, well, what if a second cousin really feels like they're tied close to the family? I mean, how close someone is sort of their own definition. And I think we're asking an awful lot for us to go into that definition. And you could theoretically say, well, you're not a close relative and offend someone.
Okay, and there is times that you don't even know somebody's related to somebody else. You know, unless they identify the person's relation, you wouldn't even know they were related until maybe later on.
Well, I'm trying to think of situations in which a family member of a client that had not actually been included in the therapy in any way could be harmed by the therapist forming a relationship with them 24 months after they stopped serving the client.
All right.
And I guess one scenario would be a parent of an adolescent,
Right.
and the concern that the work that you did with that adolescent, which we know the client carries with them, and if now you're involved with their parent, and does that somehow mess with that therapeutic alliance you might have had with that client that enabled that work, and that then by extension, does that mess up whatever the work was?
Well,
But-
that could very well interfere, because then the adolescent or the child may feel like that you betrayed them.
And another scenario might be you work with a couple, they get divorced, and you get involved with what the other partner 24 months later.
Well, yeah,
Right.
but you work with the couple, so that
You would
the
be-
couple would
That's
be
true.
clients.
He'd
And
be a
in
client
the
too.
previous scenario with the kid, I also think that the harm is still the kid. If you start the relationship with the parent, the client which was the kid, is the one that's going to be having the harm. So you're still covered by saying just the client, because that child is the one having the harm, not the parent of the child that's in the relationship.
But the reg has to do with having a relationship with someone who's not the client, but who's connected to the client, and how that could cause harm. And if you
Right.
have an adolescent and you get involved with their parent 2 years later, that yes, it could harm the client that you had because you got involved with their parent that maybe they had issues with at that time.
Right, but they're not harming the parent. And what we're proposing adding is that the parent could wage a complaint, not the child. The child's still the client, so that would mean that they could always wedge a complaint if we started dating their mother or father. What we're talking about here is that the mother could wage a complaint if you started dating the mother.
Yeah, I guess I was thinking that was in there because of the potential harm to the client, but you're right. If it's in there, then the family member that you got involved with could be the one that could file a complaint or claim that they were harmed by that.
Correct.
So go ahead.
Mary, yeah. Does anyone else have a problem with there ever being a relationship developed?
Well, that's the standard in almost all of the codes of ethics, including ours, including social work. But the unprofessional regs in Kansas, across all of the professions, did say 24 months. And I assume that's because they wanted to have a cutoff point where it could no longer be, somebody getting in professional trouble for it, even if we think it's wrong or it's unethical. I'm assuming that was the rationale for setting that 24 months across all the professions to begin with. But now at least 2 others have changed. Licensed psychology says never in the unprofessional regs, and MFT say, or did I say MFT? Said, yeah, they changed it to 60 months, 5 years. That's professional counseling. Changed it to 60 months.
Just a small difference there. They put it forward as a proposed change for the board to consider. So the regulations haven't changed yet, but that is what they are proposing for a change. Yeah.
Right. That's what they're proposing. So I think I'm hearing that there's not an appetite to add family members or relatives to this, but do we want to make it longer than 24 months, or do we just want to add this statement about that they need to be able to demonstrate, the social worker would need to be able to demonstrate that the former client is not being exploited or harmed if they choose to get involved 24 months or later.
And Cynthia, I did want to share the packet of material includes all of those proposed changes from the other professions. The very last profession in that packet is the social work one.
Mm-hmm.
And item Z on page 3 of those recommendations, I think that's probably a good starting place for this discussion.
Okay, can you put that up for us?
I can.
Do I need to stop sharing?
Yeah, go ahead and stop sharing your screen, and then I'll go ahead and pull that one up and we can take a look at it.
Okay.
All right, so you should see that here. So item Z says it would be unprofessional conduct to do the following, and then it says making sexual advances towards, including but not limited to, sexual harassment, engaging in physical intimacies or sexual activities with, or exercising undue influence over any person who within the past 24 months has been one's client. If such conduct occurs with a former client after 24 months, It is the responsibility of the practitioner to demonstrate that the former client was not being exploited, coerced, or manipulated
Okay.
intentionally or unintentionally.
So that's already in there, but
Well, I
in
thought,
the proposed.
yeah, I think we had talked about this before, so that's in there as one of the proposed ones for social work. But I think your language is a little bit different, so I was curious if maybe we should modify what this states compared to what you had on your sheet as well. So.
I mean, I think it's essentially the same.
Personally,
it says,
yeah,
it says responsibility instead of incumbent.
So like
As
we're
requested.
talking about the potential for exploitation or the harm to a client.
Yeah, if a social worker does get involved with a former client 24 months or later after that therapeutic relationship ended, then it is their responsibility to demonstrate that the former client is not being exploited, coerced, or manipulated, intentionally or unintentionally. And that on the information that I was sharing, a couple of the professions had in their codes of ethics had kind of detailed formula for assessing whether or not the former client was being exploited, et cetera. But I don't know if we want to get that detailed. I mean, it is a question of how would the practitioner demonstrate that? If anybody actually ever complained under this reg, how would a practitioner demonstrate that the former client was not being exploited, coerced, or manipulated?
And if this did go to the board for final approval and down the road, what keeps them from exploiting a client down the road, and they've already been basically shown that they were not exploiting, and so what keeps that future from having it happen after somebody filed a complaint? The board is the one that approves the final decision, correct? I mean, it's not just you, David, right, in your team. It's
No, so
subcommittee.
Yeah, there's
our subcommittee.
five members of the board that sit on a complaint review committee. And,
okay, all right.
And so the investigators collect information and they reach out to the licensee. So we would collect the complaint and then get a response from the licensee and do further investigation if needed. And then those 5 board members would meet with legal counsel and I would be there, but I don't have a vote. I basically make sure the process runs smoothly and then make sure that people are following our procedures. And then they look at all the information and see if it meets the standard for a violation. And then if it does, they look at disciplinary remedies. So.
Okay, so then fast forward. So that was all accomplished. They were found basically not guilty, however you phrase it. And then fast forward and something comes out. What protects that?
So,
well, go ahead, Dave.
Well, so anybody can make a complaint. If there was something new that occurred, that would be different. But if there was something that had been investigated, if there is essentially a dismissal, if there was a finding that it didn't meet the standard to be a violation of unprofessional conduct, then we would send out a dismissal letter and let the person know that we had dismissed the complaint. And we would send that also to the person who had filed the complaint. So they're not really a party to the proceedings, but they would get notice that either, the case had been dismissed or if there was additional action, if there's a finding of disciplinary, remedies, then that would get posted on the BSRB website.
Mm-hmm.
Yeah.
So are we going off the motto, like once a client, always a client kind of?
Well, that's what our NASW ethics say, but we're looking at that doesn't match what's in the unprofessional conduct. As far as being able to prove it, I mean, first of all, if somebody is making a complaint, they feel they've been harmed. And that would be pretty difficult for the practitioner to counter. They they feel they've been exploited or coerced or manipulated in some way. Probably the relationship's gone south, and that's why they've filed a complaint, would be my guess. But even if someone has a complaint filed against them and they're found not guilty, that doesn't necessarily give them a blank check to go do the same thing again, because each complainant would have their own story and their own facts and their own, reason for filing a complaint. So if somebody did start a relationship with another former client in the future and that client complained, it would be considered as a separate case. It would not automatically be dismissed just because that practitioner had done it before and been acquitted, if you will. Right,
Yeah.
David?
Yeah, and I think it's also important to kind of clarify the different authorities that exist when someone has done something that may be inappropriate, because our administrative authority is fairly limited. So we receive complaints from the public, but those individuals aren't party to the complaint. They notify us, and then it's really us looking on behalf of the state to see, has this person violated the unprofessional conduct or violated another statute or regulation. And then we really try to look, is there an appropriate remedy based on the limited administrative authority we have? But if someone feels that they've been wronged in a different way, that we're not a substitute for the civil process. So if someone, could sue a practitioner if they feel like they've done something inappropriate and broken the law, and we're also not a substitute for criminal procedure. So if there's something where they've, violated the law there too. So there's sometimes where someone brings something to us and it seems like more of a matter that's a criminal item. And so we kind of alert them to that. We never encourage anyone to sue someone or not to sue someone, but we also clarify that we have a different, area than the traditional civil lawsuit type discussions too.
So do we feel like this phrasing covers what we want to add to this regulation, or do we want to consider extending it past 24 months?
Personally, I like the way it is, and we've mulled it over several times.
Yes.
This is Leanne. I really think the way we have it is quite adequate. I think if we keep delving into it, and trying to change it, it's going to leave a lot more questions than answers.
Is there anyone that objects to the wording as you're seeing it on the screen right now? Okay. Let's keep that in our recommendations then to the larger board. Were there other issues in the unprofessional conduct regs that you wanted us to consider, David, or you just provided that for our edification?
Well, I think some of the other advisory committees have looked at the different proposals from the other groups,
Yes.
and have looked to see maybe did they talk about any topics that your committee had not discussed before, or maybe did they take a different approach that you thought would be helpful to bring over into yours? So it might be helpful if any members saw items for the other professions they thought would be helpful to bring over that could be brought over here now too.
So then that sounds like a discussion to take up at our next meeting if everyone has a chance to look at those between now and our next advisory committee meeting, and make a note of anything that you see in any of the other professions regs that they're proposing that you think might be applicable or might be something that we would want to look at for social work. This one we just considered was the one that I looked at all the other ones, that specific one, but there's a lot of others. So if everyone can take a few minutes to go through those before our next meeting, we'll take that up then. Okay, items for 2013 or 2023 workforce issues. Roundtable meeting with contacts from academia. We had talked about on the ASWB test issue that we were having some, the academe was pointing the finger at the ASWB was pointing the finger at academe as to whose fault it was that people weren't passing the test. And we talked about the idea of having some kind of meeting with educators and meeting with employing agencies to find out more about those positions and try and come up with some solutions, I think. David, you said that in the past, such a meeting was hosted by the board office and board members could come and attend.
Yeah, so I've looked into a little bit of the past. It sounds like at times there were, I think they were called educator roundtable discussions, and they were held at the BSRB office, and I think they were opened up for all the professions, and maybe there were some topics that were already decided in advance, but we would definitely be able to have something like that here, and even in hybrid form if we wanted to go ahead and make it some people who were here and some people that were on Zoom. But that is something that we could do. I've talked to some of the other advisory committee members and some of the board members, and there's been support for a meeting like this for some of the professions as well. So we could go ahead and come up with some topics, and then we were actually thinking of holding it a little bit later this fall. And then it's not officially a board meeting, but it would just be at the BSRB office, and board members would be free to attend if they're available, but not required to attend. And then we would just collect feedback from listening and talking to those individuals, and then provide that to the board at the next board meeting that followed that. So
I like that.
Yeah, sounds good to me.
okay.
And the meeting with the academia and the meeting with employing agencies is two separate meetings
Well, so I've
or
found,
together?
I think probably just given the different groups, it might make sense to have separate meetings for this. The roundtable for the schools, it sounds like that had been done in the past. Leslie, I'm not familiar if we've ever done a roundtable with employers, but it's definitely an interesting idea to discuss.
Yeah, no, we haven't. Usually the roundtable with the schools, we talk about like issues they're having with students or we're having with students. They bring any questions they have. No, we've never had one with employers.
Well, at some point, I think it would be good to have those two groups together because we want academia to be educating social workers for what is needed in the field, right? And the employing agencies would be able to speak to that. But I can see the point of having separate meetings initially.
Well, and it's been a few years since we've had a roundtable with the educators, so maybe it would be good this fall just to kind of host a separate meeting and then see how many people attended. We definitely wouldn't want to have too many people so that everybody couldn't be able to share their voice, and so maybe we could do them separately and then see what kind of input we got, and then kind of continue to think creatively down this road next year.
Do you need anything from us regarding this?
No,
Planning of this or anything?
we started to have preliminary conversations about looking at a possible date. So the agency's budget is due in mid-September. And so having it after that time, I think would be helpful. The board's all-day meeting is on October 23rd. So I think maybe sometime in between those two dates would be helpful. There's some conferences and other meetings, but potentially looking somewhere in that area, or maybe if that didn't work, then a little bit later this fall. I think it'd be good to just start up as a new practice and then collect that feedback and bring it back to the board and the advisory committees as well.
In the past, the roundtables were held in the fall also so that the board could update schools on any legislative changes that they thought they were going to try and put through the next year.
Sounds good. So continued review and discussion on the ASWB exam release data. You shared some of that earlier, David. Do you have any additional information?
The only thing I was thinking about in preparation for this is, some of the meetings I attend, I sort of get new updates. And I know last year we had representatives from ASWB come and speak at length about the release of the data. And it could be worth having them come to another meeting, maybe a year out. I'm sure they'd be happy to do that and provide a new update. They have made a lot of information available on their website, and they've introduced some different toolkits. But I'm sure that they have collected a lot of feedback from talking to other states. And so if that was something that you were interested in, I could reach out to them to have them come back and talk again, just as a possibility. But if not, I will go ahead and just make sure that I keep information current from my interactions with them. There is an annual meeting with ASWB later this year. And if nothing else, in the annual meeting, I should get another update in terms of how the examination is going.
So what do committee members think? Would you like to have ASWB attend one of our meetings and give us an update? Or would you prefer to have David be our communicator through ASWB?
I would like for them to come back and give us an update, just for the fact that I think they communicated some things differently to us. I would like them to know Kansas is very serious about looking into this, and they need to have us on their radar too.
Mhm.
I would
Anyone
agree
else?
with Jane. Excuse me, I would agree with Jane.
Okay, thank you. I think it would be a good idea. So I don't know when we're also wanting to have CSG come and tell us about the interstate compact plan. So I don't know when. I guess just see when they're available, David, and schedule accordingly over our next few meetings. We meet again in August, right?
Yes. So
And then in October.
Usually August, October. Sometimes the December meetings are held. Sometimes they're a little close to the holidays, and so depends on how many activities you're working on then. But at least the next two meetings should be in October.
Okay. Well, hopefully they can come one or the other of those times.
Okay.
Okay, we've talked a couple times. We've touched on the idea of the associate social work license, which is actually not being issued anymore. But the question is, would there be a role for someone at an associate level that, again, might help to ease some of the workforce shortage? If so, what kind of duties would someone at an associate level be able to provide? Now, when I was actually my first social work license in Kansas, I had an associate license but I had a bachelor's degree. It just wasn't in social work. So I don't know if we would adopt those same standards for associate licensure, so that it could be someone that has at least a bachelor's, but I think it could also be someone with just a 2-year degree. And I don't know where offers an associate's degree in social work. Is there any place in Kansas that does?
I'm not sure. Leslie, are you familiar with any schools in Kansas that offer an associate degree in
I
social work?
think so.
Yeah.
So has anyone had any thoughts or ideas about whether or not someone with an associate level of social work license, what kind of work they might be able to do appropriately? Or do we not think that's an idea we want to pursue?
In our work, attendant care is one that does not require a bachelor's degree, but they're employable to work with children and families. So I think an attendant care position would be one. Case management, most are required a bachelor of some form. It doesn't have to be social work, but I think there might be an opportunity.
This is
I
Sarah.
just don't know exactly what.
I think there's also opportunity potentially in the foster care world, child welfare world. I think of, those contract agencies that have different positions such as family support workers and adoption support workers who are meeting with families, teaching parenting skills, supervising visits. And right now a lot of those contract agencies do not require them to have a social work license to do some of that supportive work to the social worker. And so that may be a position that currently, if you just have a degree in the helping field, and some agencies didn't even require a degree of any kind up until recently. And so I think that's an area for opportunity for maybe an associate in that child welfare world.
Okay, those seem like social work support type jobs that could be very beneficial. I guess one concern I have is if we create, if we make those jobs require an associate social work degree, is that going to, because right now they don't, are they going to have more trouble finding people that can qualify for that license in order to do that job?
I don't know that you necessarily require an associate's. I think if they are willing to obtain an associate's, it may open up other doors as far as for some of those employers to provide reimbursement for further social work degrees or just certification in like training and things like that. So it may open up job opportunities that doesn't necessarily require them to be a licensed, go further on with that license, but also make it easier to be licensed or have opportunities for some of that reimbursement of tuition for further social work degrees and those kinds of things. I don't know that you would
Yes.
necessarily initially require an associate's for those. It would just be sort of an enhancement. And then that could maybe then trickle down to that pay factor too.
Yeah, a good point. And yeah, I would, go ahead.
I was just gonna say, just from a labor shortage standpoint, I don't see many agencies going back and saying, hey, we want to add these licensed positions. Most agencies offer tuition reimbursement to go to degree to agencies that have needs for social workers. Most of them are offering some kind of tuition reimbursement either. I just don't see without carving out a specific job, I don't know that anybody's going to go back and add in, hey, you need to get this 2-year license or this 2-year certificate.
Right, I that was where I was saying I wouldn't want it to be something that became a requirement, but do you think, Eric, that agencies might offer, any kind of a bump in pay or anything for someone if they came in with such a license for those type of positions?
So I'm thinking about like the state hospitals, for example, because I work through the state of Kansas a lot. And most of our pay stuff is pretty well set. And they would have to essentially create an entire new
Pay scale.
position, not even pay scale. The pay scale would stay the same. They'd have to create an entire new position. And I just don't know that there's going to be a lot of, I don't know that the need for people to go to school and get that 2-year license is going to, I don't know if there's going to be any people are going to go do that. They're either going to go for the bachelor's degree or they're just going to stick with what they have, which is not requiring anything. And I know like some junior colleges offer associate degrees with emphases in social work, psychology, several of them. I mean, that may be a criteria to get the license. I just don't know that I see any value in the associate level license unless we carve out a job to do it.
This is Leanne. I agree because right here, for tender care here, you only have to have a high school diploma and be 18 years old. Most of your family support workers, that's the same criteria. And most of the agencies, I know the agencies here, they don't even have to be licensed to be a case manager with the state to work with foster care. All they have to do is have a 3-year degree in a similar field.
Yeah.
So I don't know we'd even have any need for the associates.
I was looking at it from the public trust side. Just if we thought about it from that side, and I'm going to just use attendant care for an example, but I know there's multiple. Helping the public recognize that there is a special schooling, there's a license, there's, that scope of practice instills more trust, I think. I don't know, is it going to open up the door to a lot for workforce? I don't know. I think it's a stepping stone for the community colleges. And then to also weed out, do I want to go into this field or do I want to change now? You know, and psychology is a good example to this. At the bachelor level, they're closed down on what they can do until they go on to get that master's. And so I think if they knew all of that ahead of time, a little clearer to them, they might choose a different profession at that point. Maybe still in social work or social services, not social work, but they might choose something different.
I agree from Jane, from that public like health standpoint and that public opinion. I think it also potentially could open up doors to legitimize those workers who, you know, I think of from that child welfare standpoint, who are in the court systems having to testify. It provides some competence, you know, just that added level of competence to it because of those licensures that then helps legitimize what they're doing or the work that they're doing in a way that maybe isn't there if you don't have those things. Again, I get where Eric's coming from too, of like, you know, there may not be a huge population or what have you, but I think the population who does want to go that route, it gives them a little bit more, you know, in that legitimizing what they do.
I would certainly make those positions for those that might have that degree feel more professional or more respected, perhaps more trusted. That really segues us into the next question about a student temporary license model, which might accomplish some of the same thing as a full associate's license. Because how I'm thinking of it, and the addictions counselors came up with a student license, and it's for somebody who's halfway through their program and is enrolled in the classes to complete it, has an stated intention to work in the field, and an addictions treatment agency is willing to hire them and supervise them, and they are able to be have a temporary student license for a designated period of time where they can do some of the duties that they will have when they finish their degree under supervision, and again, make sure that's the field they want to go into. I think it has the potential to really cement that. It has a potential to steer away someone who's actually maybe out there doing the work and realizes that's not. But I think being able to start doing that work at that level, 2 years in, could certainly also be a way to increase and encourage people coming into the field. So that would be a different animal, a student temporary license versus an associate license, which could be an endpoint for someone. The student temporary license is, how long is it for the addictions counselors, David? Do they get a year or 2 years?
2 years, and it can be renewed once in case they need an additional 2 years to finish up what their coursework requires. So.
And it requires very close supervision in the workplace, correct?
That's right. Yep.
Yeah. So does that sound attractive, to try to create an entree into the field at an earlier point than at the bachelor's level?
I like the student idea, the student degree, because a lot of programs that I've either went through or taught at, they have students going out and sort of sampling positions anyway. So it might be a nice segue into that. Like, hey, you got to get your, student temp license before you can take this class.
Right. Well, I think that the way that the student temp license, the way that addictions people have it set up, people can actually go out and go to work, in an agency while they're finishing their degree. And because it can be renewed for 2 years, they could potentially have 4 years in which to finish it. So they could be working full time, going to school part time. It facilitates maybe people actually completing their degree, since a lot of people drop out because of finances and not being able to juggle.
So I got my Associates of Arts through a junior college and put myself through school for my bachelor's at Washburn for social work. And it was very hard to work full time and go to school at night. And then I wanted to go on to get my master's. And back in the day, because I've been graduated in the late 90s. But anyways, I've always wanted to go back to get my master's. And I wish there was something like this for that between a bachelor's and a master's level, because I think you really need the bachelor's to have the better understanding of what's expected in a position and the different elements that plays in that. But I think when you get to the bachelor's, you have this journalist degree and you want to get a master's, but you don't know what in or what specifically would facilitate the training that you need. And maybe this would be the point where you would want the additional training certificate to encourage that person to go on in the profession to get their master's and then do specialization and then on to the LSCSW. I think we're missing that level between there more than I think the student level for an associate's. So anyways, that's my 2 cents.
Yeah,
Those
and I
sound
think
kind of,
when the Addiction Counseling Advisory Committee initially made some proposals to the board, there was a model that was based on the addiction counseling license, and there was a model that was based on the master's addiction counseling license. And I think there were some concerns about the model that dealt with the master's in terms of some of the scope of practice, what some people would be able to do under supervision that may be a little bit more advanced than people who were not utilizing a student license, but were working in the field and trying to get their traditional license. And so I think there was some concerns about the model for the master's, but there was one that was initially proposed. But of the two, the board decided to go forward with the temporary one for the licensed addiction counseling license. So I could definitely bring those two models back for the committee to look at if you wanted to take a look at both of those, maybe at the next meeting. So.
Yeah, the one for masters was going to allow someone to start diagnosing and without any having had any clinical experience yet. And I think that was what caused the board to not approve that level of student license post bachelor's. But that could be potentially reworked, to be more acceptable. But yeah, I think would the committee like to take a look at those student licensing proposals and what the addictions counselors have adopted at our next meeting to see if it might apply to social work? We might want to propose that it apply.
It'd be really interesting to see, though, if we do the student, how that then, because I just think of from the university's perspective where they have to pay so much for some of that insurance and things like that. If they do have to obtain a student license, there may be some monetary deductions to that insurance piece that might be really enticing for some of those universities to want to get behind it and really focus on that being the goal or what have you. So it'd be really interesting to see how that would affect it too.
Yeah, good point. Okay. All right, David. Yeah, if you could get those materials out to us, maybe a week or two before our next meeting.
I'm sorry, I need to go. I've got a patient.
Okay. Thanks for being here. We're almost done anyway. Oh, it is 12. So yeah, I guess it's just right at noon now. We almost got through it, David. We didn't. The last one was coursework requirements for applicants from non-CSWE accredited programs. So we'll have to take that up at the next meeting, I guess. And that'll be in August.
And I'll send a poll out to everyone to find dates that are available, and then we can find a date for that next meeting.
Okay, great. Well, thank you everyone for being here and sticking it out for 3 hours instead of 2. Hopefully we can get done in 2 hours next time. And everybody have a great rest of your week.
Thanks.
Thank you.
Do you need a motion to close?
Oh, yes. Thanks for reminding me. Do I have a motion to adjourn?
This is Leanne. I motion to adjourn the meeting.
Okay, Leanne's motion and second.
Yes.
Second.
Thank you, Eric. All in favor?
All right.
Aye.
Aye. Okay, motion carries. Everybody have a great week.
Thank you.
Bye.
Thanks, everyone.
Bye.